Welcome once again to Lehto's Law. Here's Steve Lehto.
The Constitution seems rather straightforward, but from time to time we discover there are some nuances to it that the Supreme Court must answer and straighten out for us. And they recently addressed an issue that was pretty settled until recently, but the ruling makes sense, but doesn't clarify things quite enough. So, for instance, the police are chasing somebody in hot pursuit. They think the person's committed a crime. They are in hot pursuit of a suspected criminal, and the suspected criminal runs inside a house. Let's assume it's their house. They make it home, slam the door behind them, and lock the door. Can the police chase them into the house, or do the police have to stop outside and go get a warrant and come back with a warrant to go inside the house? And the rule used to be, for the most part, that if they're in hot pursuit, they can pursue the criminal into the home without getting a warrant. The Supreme Court has now said that is not always the case. In a unanimous decision, 9-0, unanimous, Supreme Court balks automatic warrantless searches when police are in hot pursuit for lesser crimes. And that's the distinction. Felony? Yes. Misdemeanor? Not so much. John Fritz wrote this for USA Today, but widely reported. Supreme Court's come down with a whole bunch of decisions lately. We talked about the cheerleader case a couple days ago, and this is a big one too. The Supreme Court declined to give police the automatic power to enter homes without a warrant when they're in hot pursuit of a misdemeanor crime, ruling against an officer who charged a man with DUI after he managed to get inside his garage. And so that's a twist also. The case involved a man in California. A police officer attempted to pull him over 100 feet from his own driveway. But instead of stopping his car, the man drove into his garage and shut the door. He later said that he did not know a police officer was behind him or trying to pull him over. It's all news to him. The officer entered the man's garage, questioned him, and then charged him with DUI. And I've mentioned before, I used to drive a tow truck. Drove a tow truck for the city of Birmingham, Michigan, years ago. I used to get calls late at night to tow wrecked vehicles, accidents, and so on, impound cars from time to time. And I got to the scene of an accident where a car had run into a telephone pole. Getting ready to tow the vehicle away, and I talked to the police officer and said, by the way, where's the driver? And he goes, well, there's a problem for you. He goes, we ran the plates in the car because the driver wasn't here. And the plates turn up to a house right there, and he points to a house that you can see from the telephone pole. Now, I think the driver was coming home a little sauced and saw their house and turned and forgot there's a telephone pole between where they were and their house because they had to go up and make a turn. But these things are very, very hazy at 3 o'clock in the morning. So there's a police officer knocking on the door, and the person wouldn't answer the door. And we all know why. Because the person the next morning is going to get up, go to the police station and say, hey, I was driving home last night. I hit something. But I wasn't feeling that good. I was injured. I went home. I was so concerned about my health that I didn't quite think I should. I may have forgotten to call the police. I'm not sure. And so they'll get a ticket for leaving a scene of an accident. They might even get charged with something. But they're not going to be able to get charged for the DUI because they're going to be sober when they walk into the police station. And that, by the way, is what happened. I was friends with these police officers. I heard the whole story later. That's what happened. So this happens. So in this case, the Supreme Court ruled unanimously. But the problem is that several judges wrote their own concurring opinions, so there's not one rationale that all 9 agree on. And that's going to make this confusing going forward. But police cannot just simply say, well, I was chasing a suspect, had to chase him into the house. That is no longer the case. Associate Justice Elena Kagan wrote, on many occasions, the officer will have a good reason to enter to prevent imminent harm of violence, destruction of evidence, or escape from the home. But when the officer has time to get a warrant, he must do so, even though the misdemeanant fled, the misdemeanant. And so a person who commits a felony is a felon. Apparently a person who commits a misdemeanor is a misdemeanant. I'll admit, I've never seen that word in print that I can recall. When an officer doesn't have time to get a warrant, police and courts must review the circumstances on a case-by-case basis rather than assuming the warrantless search is permitted. So police officers chasing what they believe to be a felon, they go into a house, the police can follow into the house without a warrant. They're chasing what they believe to be a misdemeanant. person gets inside the house, they got to stop and ask themselves, is there some reason why I can't go get a warrant? And then they must proceed from there. The need to pursue a misdemeanant does not trigger a categorical rule allowing home entry, even absent a law enforcement emergency. Now, Chief Justice Roberts wrote a concurring opinion that was joined by Lehto. He agreed with sending the case back to lower courts to reassess the specific circumstances, but he disagreed with the conclusion that a police officer chasing a suspect needs to evaluate constitutional principles in real time. And this is one of those things. We always talk about what happens in real life at the roadside or a crime scene or an investigation where stuff is happening fast. Boom, boom, boom. And the question is, as a police officer is chasing somebody who's committed a crime, he's got to sit there now and do this mental calculus. Oh, by the way, is this most likely a misdemeanor or is it a felony? And some of that will be rather clear-cut. Some might not be. There could be some kind of, brouhaha going on in a building, and people are screaming and yelling for the police, and all of a sudden some guy comes running out of the building, and a police officer, and people are, that's him, get him, that's him. Police officer's chasing this guy. Was it a misdemeanor or a felony? Something happened, and I'm not saying that the confusion means the police officer is always right. It's that someone's going to have to, and it's going to be a court, going to have to evaluate the circumstances and go, okay, what did the police officer know? Did the police officer act reasonably? And did the police officer have the opportunity to go get a warrant or not? So this is what Roberts is getting at. In his opinion, which he wrote, a hypothetical scene of a police officer giving chase as a suspect, for instance, jumps over a fence into a private front yard. The other people's opinion, Roberts wrote, would require an officer to stop and consider whether the suspect would be charged with a felony or a misdemeanor before following over the fence. And if it's a misdemeanor, think some more, go to have an exception. If it's a felony, go ahead and jump. The Constitution does not demand this absurd and dangerous result. We should not impose it, he wrote. We've never held that whether an officer may enter a home to complete an arrest turns on what the fleeing individual was suspected of doing before he took off. Well, and the counter to that obviously is when you come to somebody's home and the door is locked, okay, and you think there's a misdemeanant inside, and you're going to bust the door down to go inside and get them. That's when bad things happen. Things escalate at that point. And so at that point, it's like, yeah, go get a warrant, go get backup, do that right. Police are generally required to have a warrant to enter someone's home under the Fourth Amendment's prohibition on unreasonable searches. Courts have allowed exceptions when an officer is in hot pursuit of a suspect believed to have committed a felony. In the case at hand, police could only point to the man's failure to stop, which is a misdemeanor. Now, you might say, but Steve, the DUI. Well, prior to the encounter between the police officer and the driver, all the police officer had was, I turned on my overheads and the man didn't stop. Failure to stop. Now, obviously, he may have turned on the overheads because there was a suspicion that something was happening. The man may have been driving badly, so on. But there's a lot of reasons you can be driving badly. So the DUI arose later, at least the allegation or the suspicion of it. Though the difference may seem academic, civil liberty groups were concerned the case could vastly expand police powers because of the breadth of misdemeanor charges. So they were worried that the Supreme Court said, yeah, go ahead and chase the misdemeanants into the house, that would have been bad. Well, they didn't do that. Groups that advocate against drunk driving were concerned that a ruling the other way could allow intoxicated drivers to escape punishment by simply pulling into a private space and sobering up. And so that's the question. You're driving down the road, police officer turns on his overheads, okay? You're not 100 yards from your house, you're 100 miles from your house. Well, you can just pull into any driveway and do what this guy did. Yeah, you see a carport, pull into it. You see an open garage door, you pull in and close the garage door behind you. It's going to take a little bit for the police officer to realize that's not your house. I'm not advising you do that, by the way. I'm just talking about hypotheticals, which we do this from time to time on the show. Meanwhile, 5 state Supreme Courts held a misdemeanor pursuit justifies a warrantless home entry. 3 state courts and 2 federal appeals courts also said the issue must be reviewed on a case-by-case basis. This case came to the Supreme Court during a period of heightened scrutiny, of course, of police after high-profile cases of misconduct. Fourth Amendment questions have long divided the court in unexpected ways at the Supreme Court. For instance, Stephen Breyer often joins the conservatives in these disputes, while Scalia, who many people consider to be a stalwart conservative, sometimes sides with the liberals back when he was on the court. So last fall, Gorsuch called a ruling in Vermont which allowed game wardens to peer inside a garage without a warrant an error. Gorsuch, as a conservative, of course, was joined by liberal associates Sotomayor and Kagan there. And the case came to the Supreme Court after the California Supreme Court declined to hear it, allowing the lower court's ruling that sided with police to stand. So in the lower court in California, the court said the police are allowed to do this. Absolutely. Misdemeanor, chase them into the garage if you have to, chase them into the house if you have to, whatever. And I know some people are going to say, but Steve, a garage and a house might be two different things. They might be, but states have different definitions of what is your home. Your home is your castle. If the home and the garage are attached, that's a no-brainer. If they're very, very separated, they might be different, but I'm not going to get into that right now because the court is basically saying, look, this was his home. The guy made it home. So after the California Supreme Court declined to hear it, meaning they let the lower court ruling stand, then it was brought to the U.S. Supreme Court on the broad question of the U.S. Constitution and the Fourth Amendment. So they said, no, misdemeanors do not give you the blanket get-out-of-jail-free card to chase someone into a home the same way a felony chase would do it. So they might be allowed. But the bigger issue is, what's the excuse for not getting a warrant? What's the excuse? And so I've mentioned before, the Supreme Court often answers very, very narrow issues without giving guidance on the broader picture. Several reasons they do that, one of which is you can't anticipate all of the wacky factual scenarios that will arise, and quite often they do arise. So, somewhere down the road, there's going to be a case where somebody had what appeared to be a very serious misdemeanor and a great excuse to chase someone into the house, and it's going to turn out that viewed in the light of day, it looks a lot different. That'll make it to the Supreme Court also. And there are going to be more and more, litigation on this. And so it's amazing how that evolves over time. But the important thing here is that they do not have just the blanket right to do this. Or as Kagan wrote, the need to pursue a misdemeanant does not trigger a categorical rule allowing home entry, even absent a law enforcement emergency. So they might have the right to do it, but they don't automatically have the right to do it. So what's going to happen is, if someone who's suspected of being a misdemeanant, if they get convicted of what they are thought to have done, is being chased, and they run inside a home and slam the door and lock it behind them, and the cops chase them in hot pursuit, they're going to have a hearing on that. And the police officer's going to have to explain why they did that and why they couldn't get a warrant. And then a judge will rule on that, and then the appeals will ensue. So there you go. Supreme Court balks automatic warrantless searches when police are in hot pursuit for lesser crimes. John Fritz wrote it for USA Today, and a whole bunch of people sent it to me. Rick, Donald, Paul, Gayla, and Double N Dan. Thank you very much. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Your best life will not be found in comfort. It will be found in fighting for what you believe in.